Hi, it's Mike DelSignore here. In today's video, I want to talk about whether domestic assault and battery is a felony or misdemeanor offense. And domestic assault and battery is a misdemeanor offense when it's charged as a straight domestic assault and battery. I mean, there's no aggravating factors. So aggravating factors include if the victim is allegedly pregnant, if there's a dangerous weapon involved, any sort of aggravating factor would make it a felony offense. Sometimes domestic charges are also accompanied by a witness intimidation charge. This most often happens where the victim says she's going to call the police and it's alleged that the phone is yanked out of her hand or something like that, where she's prevented from contacting the police. Witness intimidation is a felony offense, but domestic assault and battery, if the allegation is merely enough to minimize it, but if it's simply that someone was pushed or shoved, that's a misdemeanor offense. The felony offense would be if it's charged as somebody slammed the door on somebody, then they would charge it assault and battery with a dangerous weapon, and they usually say to wit, a door. So that makes it a felony offense. Now, often in a case where it's charged as a felony, a lot of times the DA may reduce it to a misdemeanor if there's going to be a resolution. But typically in domestic assault and battery charges, the person doesn't want to take an admission, and we'll do everything to make sure that doesn't have to happen, because any admission is going to typically involve some kind of anger management program, batters program. These are very intensive programs and a period of probation. So domestic assault and battery can be a felony offense, and most of them are misdemeanor offenses. It depends if there's any aggravating factor, the victim's pregnant, disabled, or other circumstances that would enhance the potential penalty. Typically, these charges would still stay in district court. If you have little to no record, it'd be highly unlikely that the case would be indicted and brought to Superior Court. So once you're arraigned on the charge, whether felony or misdemeanor, the key issue is, can the government prove the case without the alleged victims? The alleged victim on board. If the person's on board, that makes it a different kind of case. Most of the time, the alleged victim does not want to cooperate with the government. If it's your wife, a girlfriend, or spouse, my experience, most of the time, the victim did not want to see you get arrested and they want to see the case dismissed. That's the most common scenario. So they can still prosecute the case if they have a 911 or other evidence to potentially prove the offense without your testimony. So how do they go forward without a victim? Well, if you confess to the crime, they can do that. If there's an independent witness who said, I saw the incident, she didn't consent, she was crying, she was upset, it was clear she wasn't consenting, and she was struck, she yelled at him after, they could go forward in that scenario. More common scenario is based on the 911 call. So the incident's going on. In the middle of the incident, the person who's alleged to be the victim calls 911 and says, hey, my husband is hitting me. Get a police officer here. He's out of control. He's drunk. He needs to be arrested, or something to that effect. The court we'd have a hearing to determine whether that's what they call an excited utterance under the law. If it qualifies as an excited utterance, then the government can use that statement without the victim testifying. And you don't have a right to cross-examine the victim at that point because they consider it non-testimonial in the law. And these are cases that are very closely decided. This is law from our highest court. The United States Supreme Court has created this law where they talk about what they call a primary purpose of the statement. If the court defines the primary purpose of the statement is to get help, then the statement is admissible. This is a very fascinating and changing area of law where, again, these are cases from the highest court in our country. And ironically, normally justices that are liberal and democratic are known to be pro-defense. This is an area where, ironically, the more conservative judges actually have a more favorable position on the confrontation clause. This primary purpose test, which generally allows the statement to come into evidence, was one of the key authors of that test was Justice Sotomayor, who was appointed by President Obama. And normally she's very pro-defense and very liberal in her thinking, but in this context, ironically, the test she sets forth is really favorable to the Commonwealth. So there's been some changes in the Supreme Court with the new President Trump nominees, and those nominees very well may take a more strict and literal interpretation that confrontation means confrontation. So this is an evolving area of law. These are contested cases, and if you have a record, this is a serious case, we may actually have to appeal the decision should a judge let the statement in. But keep all this in mind that most of these cases do get dismissed. Generally, the victims are not on board. The government doesn't often go on 911 calls. They usually do that if it's a serious case or somebody has a record. What I do is I encourage, let's say it's your wife, I encourage you to do some kind of counseling, do something so I can show to the DA that the situation, maybe that wasn't criminal, you're still denying it, but we're addressing it. Something happened for you to be in court, so it wasn't something needs to be fixed. So whenever you do something to sort of make up for an incident, to rehabilitate yourself, any kind of treatment, it's never looked in a negative fashion. A lot of people think in the alcohol context that, well, geez, if I go to AA, they're going to think I have an alcohol problem. Court thinks somebody who's in court has some kind of problem. Whether it's beyond a reasonable doubt, whether the case can be proven, is a different issue. So we always want to be able to negotiate from a position of strength, that you're doing things proactive, and it usually helps the situation with who's ever involved. Maybe they don't want to go forward, but generally there's some feelings that probably need to be addressed and dealt with for you to move on with your relationship with this person. So feel free to call me if you have any questions about domestic assault and battery, whether it's a felony, misdemeanor charge. Call, text anytime, 781-686-5924. My name is Mike DelSignore, here to help, here to answer all your questions. I handle cases all over Massachusetts.